Evening, everyone, in the room and online. My name is Uglješa Brošnić. I'm Professor of Private International Law here at UCL Laws, and it is my distinct pleasure to welcome you to tonight's event on the 2019 Hague Convention. Tonight we have two speakers, Marta Pertlius on my right, who is Professor at the Faculty of Law at Maastricht University in the Netherlands, and also at the Faculty of Law of the University of Antwerp in Belgium. Since 2019, she has been a visiting professor at the University of Johannesburg in South Africa, and since 2021, an adjunct professor at IE Madrid in Spain. Her expertise covers various fields, including international dispute resolution, private international law of the European Union, and the work of the Hague Conference on private international law. Now, of course, those of you who know Marta will know that she was a full-time member of the Permanent Bureau of the Hague Conference between 2008 and 2017. And one of the things that she was responsible for was the preparatory work for the 2019 conference. So we couldn't have a better speaker to talk about the Hague Conference and in particular how it is viewed from the European perspective. On my left is Professor Alex Mills, who also needs little introduction. He is a professor of private and public international law here at the Faculty of Laws. He is also the general editor of the International and Comparative Law Quarterly, which is the leading journal in the field. And he is the author and the co-author of numerous books, including Confluence of Public and Private International Law, Party Autonomy and Private International Law, co-author of Cheshire North and Fawcett's on Private International Law, and perhaps most importantly for tonight's talk, is the specialist editor in charge of the foreign judgment section of Dicey Morris and Collins. So he's probably in the best position to comment on the 2019 Hague Convention from the perspective of the UK. We have agreed that Marta will go first and he will speak for around 15 to 20 minutes. And then Alex will continue again 15 to 20 minutes, and then we'll have some time for Q&A afterwards.
Well, thank you so much, Uglješa, for this very kind presentation. I'm delighted to be here. I would like to first thank UCL very much and all the organizers for the effort in organizing such a hybrid event. Well, as I was saying, very happy to present this convention. I would like to I have, as you heard, 15 minutes, which is not very long for a full convention like this one. This one does not seem to work. I can also do without a size of work over here. I will already tell you. So my presentation is divided in three parts. I was asked to give you a very short idea of the amount of work that went into concluding this convention.
Perhaps if
and I have a slide there that shows, I don't think it's the most interesting part of my presentation. Second, I would like to reduce the operation of the convention to three main questions. So try to indicate how the convention works. And last, and I think the most important part, already give you some specific examples, practical examples of how the Netherlands has been applying this convention. So in terms of how we got to this 2019 Judgments Convention, it is, as my slide indicates, it was the slide I was referring to. I'm not going to give details on any of that, but as you see, it was 2011 when then my former boss said, Marta, you should go and talk to capitals, as he called it, and persuade them that it's about time to resume the judgments project. And so, you know, on these 6 years later, the Judgments Convention was concluded, and this is still not the end because there is parallel work moving forward in the area of parallel proceedings and also possibly direct jurisdiction grounds. This is as much as I wanted to say about the process that led to the convention. Let's talk about 2025, the current status. Of course, it is a very big achievement in the context of the Hague Conference because, well, those who follow the work of this organization know that it had been a long time since the last convention had been adopted, and having now uniform rules on recognition, enforcement, and in civil and commercial matters is very important. Why? Because despite several attempts, there was no operational convention in this area. Yes, there are for certain judgments already a number of conventions in place. For example, for child support or for child protection, even for choice of court agreements, the 2005 choice of court convention, but not a general one. And since the 1st of September 2023, the convention entered into force, and that was thanks to the European Union and Ukraine. And you will understand perhaps why the first case in the Netherlands relates then to an Ukrainian judgment. I will present that case later on. Obviously, very important for you is that England and Wales will apply this convention since the 1st of July 2025. And my local colleagues. I was going to say English, but then I realized that that was not, because the three of us share the fact that we were born in different jurisdictions than where we were. Good. So let's see. Moving on to what I presented to you as the three main questions that will guide us through the operation of the convention. Here they are. And I think the first question will be is deciding whether the judgment is within convention scope. I have an example in a minute to illustrate that. A second condition will be whether that judgment is eligible, and I will explain also with that example what I mean by eligible. And last but not least, even if we fulfill these two first conditions, there is still, like in many other instruments, grounds for refusal of recognition and enforcement. So what I used first as for my example is a case that some of you may know. It's a case between Real Madrid and a French judgment, and it led to a recent judgment of the European Court of Justice, where the Spanish judgment was not enforceable because it was contrary to French public policy. That's the real case. Now, for my hypothesis, I imagine that it's not Le Monde who published that defamatory article, but instead the Sun, right? And so the Spanish judgment would have to be enforced here in England and Wales. And so, moving through the three questions that I identified, the first one is the judgment within scope of the convention? And here in bullet points, you have a number of elements that will determine whether the judgment is within the scope of the convention. And those of you who have read the text of the convention will have already identified a very long list of excluded matters. I can tell you that this shows how difficult it was to reach consensus in the context of the negotiations. One of the issues that unfortunately was left out, and there are many more important ones, is defamation. And if that judgment is one where the applicant, Real Madrid, Spanish soccer team, argues that Le Monde or the Sun, in my example, my modified example, is defamating the club, well, then it's an excluded matter, the convention won't apply. If we save that first obstacle, the second question that will have to be addressed by the requested court, here an English court in my hypothesis, will be whether sufficient connection can be found between the Spanish court that rendered the judgments and the case. And Article 5 and 6 will be the guidance to determine that. Article 6 is a very specific situation only for immovable property, does not apply to my example. So you'll go here with Article 5 thing, and well, here what you'll have to do, I'm trying to go as quickly as possible, and maybe there will be questions, and I'm happy to then explain in more detail how this all works. You'll have to look at, or the court will have to look at a number of elements in the judgment. And here we have two important factors. Recognition and enforcement is against an English party because I changed the name by the son. And it's about the defamatory action, so it's a non-contract obligation. So those will help you in determining whether any of the basis of jurisdiction non-list in Article 5 applies or not. And so this will be the second test. However, there's still a third step. And here, not differently from the Brussels 1 regulations, or not differently from the English rules on recognition and enforcement. Maybe yes, differently from that, but that's for you. The exception of public policy will apply. So if you can make the case that the Spanish judgment is so contrary to freedom of expression that it really affects the the fundamental principles of this jurisdiction, then this is a reason to block the enforcement on the basis of articles. I was in a nutshell the three steps of the application of the convention. And I move now to the last part of my presentation. And as I said, in the 2 years of operation of the convention, what is it that we can say? Of course, not much, because we are still in the very early stages. But obviously, we are also eagerly awaiting the application of the convention in England and Wales as well, because we understand that this is going to probably become the main recognition and enforcement scheme between EU countries and England and Wales. On that, I should perhaps caution against the enthusiasm that this is going to have effects from the 1st of July 2025. No, because of Article 16, the transitional provision that requires the state of origin to be bound by the convention before a judgment can circulate under the convention regime. So that means that you have to wait until a new case is filed here after July 2025 for that judgment to be circulating in Europe on the basis of this convention, right? Of course, I think I mentioned that there were around 31 contracting states. That's still a limited number worldwide, and of course this convention has the ambition of becoming the worldwide instrument on recognition, and for that we miss a lot of important trading partners of both England and Wales, or the UK in general, and the EU. And you know that a number of those have signed the convention, but they have not ratified the convention. And whether they will ratify the convention in the current turmoil of geopolitical issues, I wonder. However, I would like to end on a positive note and give you two concrete applications of the convention. One is a real application, another one is an application by analogy. Let me explain very briefly. So in mid-August last year, the Court of First Instance in The Hague, which is where I happen to live, rendered a judgment, which is in summary proceedings, and it was about assets that belonged to Gazprom. I'm sure you all know Gazprom. Gazprom has assets in the Netherlands, and the question was whether those assets that had been seized, whether that seizure had to be lifted or not. And this whole question in summary proceedings depended on the enforceability of an Ukrainian judgment that decided that an Ukrainian company had to be compensated by the by the loss of property due to the occupation of Ukrainian territory in what used to be Ukraine. Yes. And this is a case that falls within the scope of application of the convention, federal scope of application of the convention. And then, of course, I would need more time to discuss with you the three questions and how the Court of First Instance of The Hague considered all of those. The judgment is published in Dutch, and I'm happy to provide you the reference to anybody who's interested. And decided that the convention here could ensure the enforcement of that Ukrainian judgment in the Netherlands. So seizure not lifted, and there will be a continuation that I haven't been yet able to respond. And I would like to thank my colleague Birgit van Houten, if she's listening, because she's the one who pointed to me that this was already there was already this first application. The second, and with that I conclude. The second is a decision by the Dutch Supreme Court, and I think it's relevant because it is the highest instance in the Netherlands, that already in 2023 rendered a judgment where they actually took inspiration from Article 4, Paragraph 4 of the Convention, which is a rule that basically says that even a non-final judgment could be recognized and enforced, but that you then need to take some precautions, of course, because if the final decision is reversed, because you already have a decision on enforceability. So Article 4, Paragraph 4 is not part of was not part of the Dutch legal system when the judgment was rendered. However, it is referred to in the judgment and now incorporated into Dutch rules on recognition and enforcement, that, like the English ones, are court-based decisions, are court-based rules, and are not statutory provisions or judgments coming from outside of the European Union. Good. So I would like to thank you for your attention, and I'll be happy perhaps to contribute to the discussion at a later stage.
Thank you so much, Martha. Alex, you have the floor.
Thank you very much, Professor, and add my thanks to Martha for joining us this event as well. So I'm offering an English perspective on the Hague Judgments Convention, and I suppose I'd like to start by explaining why it's an English perspective and not a UK perspective. It's the UK which, of course, signs up to international conventions like the Hague Judgments Convention, but the recognition and enforcement of judgments is a devolved matter in the UK, which means that the UK doesn't automatically sign up on behalf of Scotland or Northern Ireland. When the UK signed up to the Hague Judgments Convention, it entered a declaration saying that for present purposes it only applies in relation to England and Wales. That declaration can be modified by the UK to extend its application to Scotland and Northern Ireland. And there is at least an expectation that is going to happen. This was discussed in the parliamentary debates in Westminster, and when the UK was sort of implementing the convention. But as of yet, that hasn't happened. So as things stand, the convention will only come into force for England and Wales, and not for Scotland and Northern Ireland from the 1st of July. So viewing this convention from an English perspective, obviously part of the big background here is Brexit, right? And this convention is to some extent a replacement for the EU rules which used to apply, which used to allow for the free movement of judgments between the UK and European Union member states. And the convention does, to some extent, replace these EU arrangements, although of course it's broader than that because it's not a regional convention, it's a convention which has at least aspirations to be a global convention. So I'll say a little bit more about these things. I think it has to be acknowledged that the convention, the effects of the convention are a little bit complex. And assessing it, I think, does require a little bit of a nuanced and balanced assessment. So what I'd like to do is highlight what I think are three of the key benefits of the convention, but with three key provisos, three on the other hands, for each of the sort of key benefits that I want to illustrate. I think my overall conclusion is that this is a positive development, but you know, the benefits outweigh the challenges, but you know, we have to understand the challenges as well. And by way of quick background, for those of you who might not be familiar with the English approach to the recognition and enforcement of judgments, apart from the Brexit transitional rules, there are presently 4 different sources of rules on the recognition and enforcement of judgments in England and Wales. There's the common law rules, which apply still in most cases. There's the Administration of Justice Act 1920, which is a statutory sort of framework that was set up to support bilateral treaty arrangements between Commonwealth states, and a number of those are still in force. This is a statutory sort of arrangement based on treaties between the UK and other Commonwealth states. There's the Foreign Judgments Reciprocal Enforcement Act of 1933, which is a similar kind of idea, but it isn't limited to Commonwealth states. And there are also some bilateral treaty relationships between the UK and other states, which provide for recognition and enforcement of judgments between states under that regime. And then finally, the fourth body of rules is the Hague Choice of Court Convention, and also the work of the Hague Conference, which applies to judgments based on exclusive choice of court agreements in favour of convention states. So the Hague Judgments Convention adds a 5th major source of rules into this mix. Now, under each regime, the sort of core principle is that we have various defences to enforcement, which try to protect defendants, for example, against fraud or violations of procedural fairness, and so on. But you don't get to re-argue the case on the merits. In general, the focus isn't whether the judgment court got the decision right. The focus is whether the process is fair. Right? That's a key basic sort of principle guiding all of these regimes. But each of the existing regimes is quite restrictive in terms of what judgments it applies to. And so in general, the existing law, the current 4 regimes, only allow for the enforcement of judgments either given by a court where the defendant was physically present or had a fixed place of business when the proceedings were commenced. And this is the presence test under the common law, or where the defendant submitted to the jurisdiction of the judgment court in one of a number of different ways. So what are the 3 benefits and the 3, on the other hands, for the convention? In no particular order. The first benefit, I think, is about the information costs of litigation planning. So what do I mean by this? Hague 2019 provides unified common rules for recognition and enforcement of judgments in a handy, easy to read document. And this potentially reduces the information cost of determining whether a judgment is enforceable elsewhere. You don't have to become an expert in French law or German law. You can consult your Hague Convention to determine the answer to this question. More significantly, it helps in determining whether a hypothetical English judgment is going to be enforceable elsewhere, which is potentially a kind of precondition for bringing proceedings in England. What I mean by this is, you know, if you're deciding where to commence proceedings in a cross-border case, and you need to think not just about the advantages of where you're going to litigate, not just the procedural and substantive rules that are going to apply in that court and whether those are going to be advantageous to you, but whether the judgment you get is actually going to be practically enforceable, whether the judgment is actually going to be of value to you in a more practical sense. And so Hague 2019 makes it a bit easier to know the answer to this question. And the benefit of this informational this reduced informational cost will grow as the number of state parties grows, right? Because that same information becomes more and more useful. Side benefit of this benefit, English lawyers can advise, at least to some extent, on the enforcement of English judgments in foreign jurisdictions, which is something that English lawyers probably can't or shouldn't do unless they happen to also be experts in foreign law. at the moment. So there's an additional benefit in being able to actually advise your clients on the enforceability of an English judgment under this treaty regime. On the other hand, the Hague 2019 rules are not exhaustive, as Martha already pointed out. The rules are sort of positive, not restrictive, in the sense that they facilitate the enforcement of judgments, but they don't exclude the operation of any other rules. So it's clear from the convention that you can still rely on the common law rules or the statutory rules, even in cases that are also covered by the convention, so to enforce judgments from convention states. And equally, you can still rely on foreign national rules to enforce judgments from England and Wales, even when those fall within the scope of the convention, with one exception that Martha mentioned around immovable judgments relating to immovable property, which I won't go into. So this leaves open the possibility that an English judgment, although not enforceable under the convention, could still be enforceable under a foreign state's national rules. So the Hague 2019 Convention gives us easy access to information, which can tell us potentially if a judgment is enforceable under that convention, but not necessarily to complete information, because we don't necessarily know just by looking at the convention if a judgment is not capable of enforcement, right? We can tell if the judgment is capable of enforcement under the convention, but that doesn't rule out the possibility that it still might be enforceable in some other way. And so the Hague Judgments Convention sort of potential downside is that it adds another body of law that we have to look at to get complete information. To complicate things a little bit further, Hague 2019 rules are, of course, rules established in a new treaty. They require interpretation to clarify their meaning in certain respects. And the meaning of various terms in the convention is intended to be interpreted autonomously, which is to say, independently from their meaning in the national legal systems of each of the convention states. So we might need some guidance on what contractual obligation means for the purpose of the convention, on what fraud means for the purposes of the defenses under the convention. Add to this the fact that different language versions are equally authentic. Right? It's not just the meaning of the English language version that we're concerned about. So the process of determining the meaning of the convention is not always going to be straightforward, at least in the short term. So the informational benefits of the convention have to be taken with that kind of qualification. Although I would say that there is an excellent explanatory report, which is helpful here, and a long and excellently documented negotiating history to draw on. Thank you, Martha. The second benefit of the convention is what we might describe with a sort of tongue slightly in cheek as the judgments export boost aspect of the convention. So the convention has to some extent been sold as a way for English judgments to be more easily exported to other states, and particularly around the European Union. And of course, this is true, right? The convention provides streamlined rules which replace to some extent those under the Brussels regime, and now replaces situations which are presently governed by the national law of each of the other convention states. But there's another way. The purpose of the convention isn't just to provide information, right? It's not just to make it clearer what the rules are. It's actually to enhance the recognition and enforcement. It's to make it easier for judgments to be recognized and enforced between convention states. So there's an opportunity created here for easier enforcement of judgments. Again, not just to enforce a judgment once you have it, but more importantly, to think about this when selecting between different courts. Right? It makes it more likely that a judgment from the English courts is going to be enforceable. So it opens up the possibility of choosing the English courts to more parties or to more types of disputes. And this is primarily because there are a wide range of jurisdictional grounds which support the enforcement of judgments. And these are wider than the grounds that are going to exist under many national legal systems. This is the list of jurisdictional filters under Article 5 of the Convention that Martha already mentioned. Hague 2019 also expands the recognition and enforcement of judgments in another way through expanding the types of judgments which are enforceable beyond monetary judgments. So under the common law rules, applicable not just in England and Wales, but in most other common law systems, only judgments for payment of a fixed sum of money are capable of enforcement. The Hague Judgments Convention allows for the enforcement of a much broader range of judgments. So this would allow, for example, for the enforcement of orders for specific performance as a remedy given in a contractual dispute. And this adds a kind of further strategic benefit, right? Because if you're thinking about where you should litigate, should I litigate in country A or country B? And you're thinking about, well, if I litigate in country A, will the judgment be enforceable in country B? At the moment, you also need to think about what kind of remedies could I get in country A that would be capable of enforcement in country B under their rules of recognition and enforcement. So expanding the categories of judgments which are capable of recognition and enforcement also frees up a little bit your choice of where you might usefully be able to litigate your dispute. There's another interesting side benefit here, which is that actually the enforceability, the greater enforceability of English judgments makes it more likely that the English courts will actually exercise jurisdiction if proceedings are commenced in England. Because one thing the English courts take into account when they're deciding whether or not to exercise jurisdiction using their discretions of forum conveniens and forum non conveniens is whether the English courts hearing the dispute will practically resolve the dispute, right? Will they actually be able to resolve the dispute in a sort of effective way? And the more that English judgments are going to be recognized and enforced in jurisdictions where the defendant has assets, and so the English judgment will actually be given practical effect, the more likely the English courts are going to say, yes, an English judgment will be a valuable means of doing it. And so there's a sort of side benefit here, which actually slightly increases the prospects of the English courts hearing cases once they've been commenced in England. On the other hand, the Hague 2019 rules, like the Brussels regime rules, are reciprocal. So they don't just allow for the export of English judgments, they require the English courts to import judgments just as much as they export them. And this creates a bit of a challenge for English defendants. So under the common law rules, foreign judgments are enforceable in England based on very limited circumstances, the situations of presence and submission that I talked about earlier. And again, only monetary judgments. Right. So this means that there's a lot of situations where English defendants in foreign proceedings might choose to ignore those proceedings. Because even if a judgment is given against them, that judgment will be unenforceable in England. And if that party doesn't have assets in that jurisdiction, doesn't plan on having assets in that jurisdiction, they might just say, I don't need to worry about those proceedings at all. That calculus has to change under Hague 2019. English judgments will be given greater international effect. But the flip side is that judgments from other convention states will also be given greater effect or more easily be given effect in England. And so English defendants will have to go and defend themselves in foreign courts more often than they currently do if they're worried about a judgment being given against them. There's a lot fewer circumstances in which you can simply ignore the foreign proceedings because the judgment won't be enforceable somewhere where you have assets. What this means in practice is that the key benefit of the convention is probably not going to be so much that we export more judgments, because we're both going to be exporting and importing judgment. The kind of balance of payments of judgments is probably maybe going to be relatively sort of neutrally affected by the convention. The key difference is that it means that there are more courts where an effective judgment can be given, which means that when parties choose where to litigate, they won't be limited to a sort of small number of courts. Parties will have more choice of effective courts and are therefore likely to choose a court which is actually more efficient or potentially maybe to open up greater opportunities for forum shopping for claimants, because the judgments, the courts that they choose may be more likely to give an effective judgment. And this also highlights, of course, we're dealing with cases here that are covered by exclusive choice of court agreements, highlights the importance in transaction planning of having exclusive choice of court agreements to manage litigation risk, to manage the possibility that you might be sued in a court that you don't want to end up. There's another important point to note about Hague 2019, because it doesn't affect the enforcement of judgments based on exclusive choice of court agreements. Those are covered by Hague 2005, but it does affect the enforcement of judgments based on non-exclusive or asymmetrical choice of court agreements, more specialized or other types of choice of court agreements. And that's quite interesting because at the moment, given that we only have internationalized rules for exclusive choice of court agreements, the system is kind of biased a little bit in favor of parties choosing exclusive choice of court agreements. You get more benefit from choosing exclusive choice of court agreement than you do from choosing other kinds of agreements. So one effect of Hague 2019 will be to a little bit level the playing field between different kinds of jurisdiction agreements. And that'll perhaps open up the possibility that parties might sometimes prefer to have, let's say, an asymmetrical jurisdiction agreement, because they know that a judgment based on that will be enforceable under the Hague 2019 rules in the same way, under very similar terms, as a judgment based on an exclusive jurisdiction agreement is enforceable under Hague 2005. The third benefit of the convention that I wanted to mention is its multilateral framework, right? And this is the aspiration of the convention to establish this global harmonization of rules on recognition and enforcement of judgments. In the long run, it potentially could establish a global system which radically simplifies and introduces this kind of cooperative element into this area of law, improving the functioning of global markets. So the convention is actually really historic. It is a dream of the Hague Conference since, well, before it was an institution, when it sort of started as meetings in the 19th century. This was one of the key kind of dreams of the Hague Conference. So this is quite a remarkable thing. On the other hand, again, so Hague 2019 is multilateral, but it's also bilateralizable, which is to say that states can object on a bilateral basis to the convention coming into force as between them and any other state at the time when a state becomes party to the convention. So when a new state joins, there's a 12-month period during which that state can object to the convention coming into force between it and any of the existing states, and any of the existing states can object to the convention coming into force between them and the new state. Right. So this is why there was a 12-month delay between the UK ratifying the convention last June and the convention coming into force on the 1st of July this year to allow for this process to work its way through. No one's objected to the UK joining. I'm sure you'll be happy to know. But this could potentially be applied in case, for example, not to single out any particular states, but Russia were to ratify the convention, right? I imagine that states would avail themselves of this opportunity. And this facility creates some wider practical and political challenges, right? If a state signs up to the Hague Judgments Convention, ratifies the Judgments Convention, when should you object to that? What level of systemic risk of that system is too much for you to allow that convention to come into force? Is this a political or purely a legal decision, right? If some state that the UK is internationally allied with, but has a slightly unreliable legal system, ratifies the convention, is the UK really going to object to the convention coming into force as between it and this foreign state? Maybe, but it's going to be put the UK in quite a tricky position, right, in relation to states that it might not want to exercise those kinds of judgments over. But this mechanism requires it to exercise that kind of judgment. So there's a real challenge here in how you balance the kind of political factors involved in these decisions with the interests of individual litigants, right, who might end up being subject to unfair judgments if you allow the convention to come into force, because there isn't that possibility to review the merits of the judgment. Of course, if the judgment is procedurally unfair, you can still rely on the safeguards under the convention, and that might be enough. But it's not always going to be easy to prove for a defendant. Hague 2019 is a bit challenging here because there isn't any mechanism to block the bilateral relationship after it's established, basically. There's no there's no means of addressing the problem of if you've allowed the bilateral relationship to come into force, but then the state that you have that relationship with has a kind of rule of law collapse, right? And their courts are no longer reliable sources of judgments. It may be that you have to withdraw completely from the convention in those circumstances. It may be that a partial withdrawal might be possible, although the Vienna Convention of Law Treaty suggests that it's probably not, so it's a bit of a tricky situation. Hopefully this is a theoretical rather than practical difficulty, although recent experience suggests that rule of law challenges can arise even in some states which were thought to be reasonably well-established democracies, again, not to name any names. So overall, my assessment is that the benefits of the convention do outweigh its costs, but it is important to be aware of those costs, of those complexities and effects of the convention. It does create opportunities for English courts to expand the practical reach of English judgments and for English lawyers to advise on these questions. This will have some incidental effects on parties' ability to choose between different forums or the attractiveness of different courts. But it equally creates risks for English parties and their lawyers who need to be careful to understand the greater effect that foreign proceedings might have in future when it comes to the enforcement of prospective judgments against English assets at home. Thank you.
Thank you, Alex. We have just under 20 minutes for Q&A. So I'll open the floor to the audience. If you ask a question, could you please introduce yourself? And maybe we'll take 3 questions in the first round. And if you could tell us who the question is for. Is it for both speakers or maybe on one of them?
Hi, I'm just an external visitor. I used to be a lawyer, I'm a student there. Thank you for the presentations, very interesting. Question for Professor Mills. What was the process in the UK by which it was decided to ratify the convention? Did that go through Parliament? Was there an instrument? Because looking at the other 4 methods by which a judgment is enforceable here, 3 of them were by Act of Parliament, 1 was the vote of common law. So what happened? Was it just a government decision under the law? Yeah.
Thank you. Do you have any other questions in the audience?
The convention mentions that it is not applicable to arbitration and related proceeding. So if a seat of the arbitration is giving a judgment, the court of the seat of the arbitration, then will it be affected by the convention or not? And if it's not, then majorly now disputes are settled by arbitration. So how much effective would this be for businesses?
Sure. I think you respond first.
Thank you. Let's ask both panelists about the fraud exception and what that actually means in practice. So under Hague 5, it was limited to procedural fraud. We're now told it's substantive. And I just wonder how the autonomous interpretation feeds into this as well, with the English court's current approach of allowing the receiving court to have a second bite of the cherry in deciding whether there was fraud even decided.
Thank you. Nothing we understand.
I can take them in the reverse order because I think that.
Yes, I think there were two questions for both speakers, and then there was one question on the line.
Um, I'm not sure I fully understood, but otherwise Alex will provide me with a more definitive answer. Yes, I think you are asking about the policy choice, whether it is possible under the 2019 Judgments Convention to indeed possibly rethink or reassess something that has already been decided by the Court of Origin. Is that your question, or did I misunderstand?
Yeah, so more specifically, just the fraud exception.
The fraud exceptions. Yes,
Yes,
it's there, so I would say, like the 2005 Choice of Court Convention, there is a ground for refusal, so I think it will, there will be the opportunity for the requested court to reassess that question, even if the Court of Origin already discussed it, so I see no way out from Article 7 in that case.
Should I jump in on that one?
Yes.
So, yeah. So I mean, the difference that you highlight between the 2005 convention, which focused on a kind of procedural conception of fraud, right, and the 2019 convention is obviously a deliberate one, and I think that has to feed into the interpretation of that provision. So it must be not limited to fraud in relation to a matter of procedure. Beyond that, I think it's one of these categories of concepts which, interpreted autonomously, it's a bit challenging to know what that means. And an autonomous interpretation of international treaty of this kind, it truly is a search for a kind of global meaning of what fraud means. It's not enough to look, between the existing states and say, well, what do we all understand? It's enough to look across Europe. So that's quite a challenging task for judges to try and understand what fraud might mean in a sense which is detached from any particular legal system, right? So that's I think one of the big challenges of legal harmonization in this field, is that it requires this kind of slightly imaginative leap for judges. On the other hand, judges are in England and Wales and elsewhere are very experienced in interpreting treaties and in identifying the independent meaning of treaty provisions. So it's perhaps not such a challenge for them to detach themselves from their domestic understanding of fraud.
I will move to the
Yes.
question about arbitration versus litigation. So yes, you're absolutely right, it's an excluded matter and again, a deliberate one, because there is a parallel regime of the New York Convention. However, I understand your question as saying what happens when we have a case where the two come together and how are we going to make that distinction? Well, as you know, have been having a very heated discussion on that matter in the context of the Brussels I regulation, and I come from Spain. I know that there was a particular case in this jurisdiction that gave rise to a lot of debates, rightly so. And I expect a similar, let's say, discussion to arise at one point in the context of the operation of this convention, because, as you know, well, there are many instances in which arbitration and litigation coexist in the context of the same dispute.
Yeah, the only thing that I'd add is just that the explanatory report does have a provision which says that the arbitration exclusion should be understood to mean that a foreign judgment which is contrary to an arbitration agreement may be refused enforcement on that basis. And so that kind of question, even if the foreign court has decided that the arbitration agreement is invalid in the course of its proceedings. So that question that's been such a struggle in the European Union is addressed in the explanatory report in, say, the way that the English courts have interpreted that rule essentially. And the explanatory report isn't binding, but I think it's likely to be taken, it's likely to influence the approach of the courts. The other sort of reverse side of that is if you have an arbitration agreement and then you get your arbitral award, and then you get a judgment giving effect to that arbitral award, whether that judgment would then be capable of recognition and enforcement under the rules. And It's not entirely clear, but I think the better view is that it would be, because it's a judgment entered to give effect to an arbitration agreement rather than itself being an arbitration judgment. But it'll be interesting to see what approach is taken to that. Of course, you could also rely on the enforcement of the arbitral award in other legal systems, which would give you the same effect. So it's unlikely to be a significant practical problem. And then there was the first question about the process in the UK to ratify the convention. I suppose one thing I should say is that there was a public consultation which took place. So there was the opportunity for a certain amount of engagement, and there were some hearings and so on, some consultation. But in terms of the means of implementation, as part of the UK's withdrawal from the European Union, a statute was passed, which I think is called the Private International Law Implementation of Agreements Act. And that act created the power for the government to implement other private international law treaties by statutory instrument. So private international law treaties are in a slightly unusual position because of that statute, which is to say they don't need an act of parliament, they only need a statutory instrument to implement them. And that's what was done in this case. A statutory instrument has been adopted, which gives effect to the treaty. It does that through amending the Civil Jurisdiction of Judgments Act of 1982. And the convention is annexed as a schedule to that act, and it's given legal effect through a statute in that act. But those changes were made by a statutory instrument rather than by primary legislation. So the statutory instrument was discussed in committee, but I don't know that it received a huge amount of debate in Parliament. Whether you think that's a satisfactory arrangement, I think is something that is reasonable to talk about, because I think this is quite a significant change. There were lots of opportunities for people to engage in the debate. There was consultation, so it's not like this was done without there being a lot of advance public notice. But I'm slightly uncomfortable with the process of ratifying and implementing a treaty through a statutory instrument in this way. I feel like Parliament has slightly sidelined itself by adopting an act which gives the government the power to do this, right? I think that's what's happened in this process, and I think that's quick and expedient and efficient. But I'm not sure that these issues should be viewed as kind of mere technicalities that should be left to the government to sort out. I think I think it would not have been a bad thing if this were debated as an act of Parliament.
Thank you. We have enough time for a second round of questions.
Thank you for your presentation. So my question is quite a straightforward one and is addressed to the full panel. So my understanding is that under Hague 2005, the date of the jurisdiction clause is relevant, whereas under Hague 2019 it is not, in the sense that an exclusive jurisdiction agreement that was agreed before the Hague 2005 entered into force would be actually caught by Hague 2019, is that right? Kind of, if we think of the interplay.
You want to take that one?
Well, I think we have two more questions. I think there's one question in the back of the room there and in the back of the room there.
Yes, quick provider, Malcolm Chambers. This question may have been asked by today, but it's striking that the number of people, number of countries, states wishing to sign up to the Hague Convention is much lower than the New York Convention. Are speakers able to enlighten us as to why that is the case?
New York.
New York Convention,
And there was one question in the back of the room there.
My name is Sean, and I'm a student. Martha mentioned that the convention has been a long-standing aspiration. So I want to ask if there are any challenges in getting everyone to agree to the uniform rule and how they're going to perform. If there are any challenges.
So we can answer these two questions and hopefully we'll have enough time for them.
So again, perhaps in the reverse order, Yes, you're absolutely right. The challenges become bigger the moment there is even more tension in the world. And so even the signatories, to those who have signed the convention, which in international law is an indication that they are working towards ratification, are taking their time, right? Yes, those I think are the challenges. This is a still civil and commercial matter. I think states these days have many other priorities to take into account in terms of international relations, and so that explains a bit how this process is a slow one, which in a way brings me back to the second question. I always say that the New York Convention took 50 years to establish itself as an international instrument. I'm talking about the 1958 convention. So we will need to give the convention its time, and we are only less than 10 years after conclusion. So I think it's a matter of time, linked to the fact that the world has become a more difficult place to be even since 2019. And remember the discussions on the bilateralization that Alex presented. And many delegations back then thought that this was absolutely unnecessary, and it was a big drawback and a big limitation for the operation of the convention. People refer to the fact that no ACCH convention had a similar element other than the ones that have been adopted in the 60s. Still, look where we are now and how likely it is that this Article 29 will be used effectively. So yeah, bittersweet reaction there. Yes, the first, which
maybe just quickly on that. And I guess one difference between the New York Convention and the Hague Conventions is because parties get to choose their arbitrators, they get to choose their issues, they have a little more control over the institutional apparatus. And the analogy is more closely with the Hague Choice of Court Convention than the Hague Judgments Convention. And the Hague Choice of Court Convention, I think, is probably picking up popularity. I mean, there's been some debate about the adequacy of the defences in the Hague Choice of Court Convention and whether they, in certain circumstances, might allow for a kind of danger of bootstrapping that a court deciding that there is a valid exclusive jurisdiction agreement in its favour, that decision ends up being binding on other states in a way that might be unsatisfactory. So there's some debate about some of the provisions in the Hague Choice of Court Convention, but I think actually it is growing in popularity, and with enough time, I think could be a parallel convention to the New York Convention. The Hague Judgments Convention is a sort of trickier prospect because it does depend on a kind of institutional trust in other states' courts, which is a more complicated thing. And something that in situations where parties aren't exercising control or choice over that. And just the other thing to sort of mention in terms of the challenges of reaching agreement on this, the Hague Conference works on a consensus basis, right? So there isn't even a kind of process of getting a majority vote to get something through. So as an institution, it has to work extremely hard to build consensus on common ground and find a way for to have provisions that everyone can agree on, because you end up with these exclusions. But I think it's a remarkable achievement that that they were able to agree on the core text of an instrument like this.
I think there was one question.
And then, so the exclusion of jurisdiction agreements of judgments based on exclusive jurisdiction agreements in the Hague Judgments Convention isn't limited to exclusive jurisdiction agreements which are covered by Hague 2005. It's just a blanket exclusion. So there isn't the possibility for an exclusive jurisdiction agreement that sort of predated a state's accession to Hague 2005 becoming indirectly effective. It's a nice idea, but the way that it was excluded doesn't allow for that possibility. Yeah.
Thank you. Yeah. So on that one, so if I understand you well, if there is a judgment that was rendered in breach of a choice of court agreement.
I know we're talking about judgments based on
Based on
a choice of court agreement. If the choice of court agreement sort of predated, sort of fell outside the temporal scope of Hague 2005, put it fall within the scope of this, but they're just completely excluded.
Unfortunately, it is 7 o'clock and we need to finish now. But fortunately, there is a reception outside. So there are some drinks enabled waiting for us. So I would like to thank all of you for coming and please join us outside for some drinks. And I would like to particularly thank Martha for coming all the way here and talking to us today, and to Professor Mills, Alex, for your contribution. And I'd like to invite everyone to thank the speakers with a big round of applause.